Good evening.
You are live with Courtside with Lawman,
And Carmen B.
and we are here to talk about legal issues that affect the public and affect the community.
We're informational.
An educational show.
Yes. So we would like you to share your thoughts, subject matter, and things like that with us throughout the evening, the 30-minute show. And we'll try to discuss it. We'll try to bring up other things. But tonight we have a part two of our subject matter regarding new laws and how they affect you here. Now, got to give you a proviso that anything we say, we're not creating an attorney client relationship with Carmen or myself.
Yes, so if you post a question in the chat, we certainly will answer that question for you, but the answering of that question does not pose an attorney client relationship. If you need a private consultation, you can contact me, Carmen Butler, at 916-443-5288, or
Or you can
Lawman.
call me at 916-443-5600. All right. I think that's all the beginning stuff, Carm.
I think that is it.
All right. Let's see. It's
Oh,
going to.
one last thing. If you want to call into the show, you can call in at 916-443-5288, and we will answer your question that way, or you can post it in the chat.
Absolutely. So the title, New Laws in 2022. And what we were talking about were laws that would affect you that have just come out here in 2022 and that are being in effect. We're going to follow up with a couple of them, and some of them involving DUIs. So you want me to start off with one, Carl?
Since you are the DUI master, of course.
Okay. There has been a large battle in California over whether or not DUIs fall under the recent legislation um, that allows diversion for any misdemeanor offense. So we had a new law last year that said that if it's a misdemeanor, a court may give an individual diversion. Now, what diversion is diverting the judgment on the offense until and if you have jumped through certain kinds of hoops and requirements that the court will require you to do during a 1 year or a 1 year and a half time period. So it's a way, we call it diverting the charges from ever being put on your record as a conviction, as long as you take certain classes, do community service, pay restitution, several different things that the court can order you to do in that 1 year or year and a half, depending on the court, in order to satisfy the court enough to where at the end of that period, the court then dismisses the charges. Did you want to throw something in?
Yes, I was just going to say that you have to understand that anytime that you are arrested, the arrest is going to still show up on your rap sheet. But after the arrest, or it'll say arrest, detention, or citation, and it'll show what the charges were. After that, it will indicate what the resolution was at the time of the court appearance. And so if you complete the diversion program, it will show as a dismissal.
So, diversion is not new. It's been around for quite a while. Sometimes they have what we call informal diversion in the past, which is the judge would merely say, hey, if your client does this, this, and this, hell, I'll dismiss it at the end of the year.
Mhm.
And it wasn't anything formal about it. But this is a more formal diversion only because the court has the opportunity to grant the diversion without the DA agreeing to do so. So if it's a misdemeanor, it's taken out of the DA's hands if the court agrees to give you diversion. So it became a big issue because, like I said, all misdemeanors are subject to this. But the argument was, are DUI subject to it? And the controversy is there because we know there is all kinds of money that goes to DA offices to prosecute DUIs. DUIs are seen as not normal crimes like others are. They are special kinds of crimes because you can have a misdemeanor DUI and you're driving at an '08, or you can be DUI at '08 and you kill someone. So that act of driving with the amount of alcohol in your system that affects your ability to drive could have tremendous consequences, or it could just be a slap on the wrist, a little wet reckless or something like that, and you pay a fine. So now what legislation allowed is DUIs to be part of diversion. And what began to happen is all over the state, lawyers began to ask for diversion for DUIs, and courts were in a quandary because they didn't know whether or not the legislature had included DUIs to be part of diversion.
Now, did it matter if it was a first or a second or a third DUI?
It did matter at first because it had to be a misdemeanor, so it definitely couldn't be a fourth offense. And the third offenses, you just wouldn't get diversion because the court had a right to say whether or not you did. But a simple first offense, DUI, when no one's hurt, no accident, clearly is like any other misdemeanor. And what was going on in the fight was this: the legislature, when they passed this bill, they actually argued about whether DUI should be included. They considered that. And in both the Assembly and the Senate's argument, DUIs were to be included. Now, you knew that because they weren't excluded. There are some things that are excluded, like sex offenses, DV offenses. So it was clearly contemplated by the legislature, and then the law passes. So the big issue is, well, wait a minute, did they really mean for DUIs to be included? And what you saw happening all over the state were lawyers filing motions so that misdemeanor DUIs could be given diversion. What you had was courts with different opinions. Courts in the same jurisdictions would have different opinions. One court would rule one way, one court would rule the other way. And when I say court, specifically a judge who would make that decision. So even the judges disagreed on whether or not that would apply. Here in Sacramento, when it was challenged, it was ruled that DUIs are not to be included as part of diversion. And all the other judges pretty much were following along because they wanted some kind of congruency amongst themselves to take that position. So that issue has been litigated for quite a while. And there's a decision that just came out not too long ago, maybe a week ago. Grassi, Garsi is the name. And in that decision, the court said that DUIs are not to be included as part of diversion.
Was that a Supreme Court, California Supreme Court decision?
It was an appellate decision in the fourth appellate district, which is the right before the Supreme Court. So the Supreme Court now is going to probably have to deal with it because there are several writs that individuals has filed that's still there to be decided. So the way it sits right now, because of that, is that there are several lawyers who are saying, hey, wait a minute until other jurisdictions make their decision before we issue some blanket thing here in California. Now, the problem is going to be that while that's going on, no judge is probably going to grant the diversion because they know that the outstanding litigation is there. So they can take the safer route by saying, well, I'm not granting diversion for DUIs. And so what you could have had may now have been taken away in our new law that's come out because case law is new law. So that is probably going to be taken away. And whether it's good or bad, in the end, we really can't measure that. But what it did do was it allowed for individuals who did pick up a DUI like any other misdemeanor to get it dismissed off their record when that DUI could possibly ruin their career, profession, their license, all kinds of things that would have been ramifications from one simple DUI. Simple meaning no injury, no accident. You see things like that.
And I just want to be clear again that a dismissal resulting from a diversion program is not a finding of factual innocence. It does not erase the arrest from your record, but it shows that the end result of it was a dismissal. And so it'll show up on the record as a dismissal. And anyone can have the unfortunate luck of getting a first DUI if they're not conscious of their drinking. Someone may have just had a glass of wine with their dinner, but because they're small in stature, it was enough to to put them over the legal limit.
Yeah.
We have known DAs who have gotten DUIs. We've known other attorneys who've gotten DUIs.
Pastors.
Recently, yes.
Police officers.
Police officers. Recently, in the national news, I believe there was a judge who was arrested for DUI. So anyone can make that mistake. The best way to avoid that is, if you're going to have any amount of alcohol at all, do not drive. We live in a day and age where Lyft and Uber are readily available. So if you don't have a friend who can be that dry driver, use your Uber, use your Lyft.
And let's just go back a little bit and realize this now. Drinking and driving is not necessarily illegal, okay? What is illegal and what the statute prevents is that you drive with a blood alcohol content of 0.08 or higher, or, as the A statute says, that you drive a vehicle unlike a sober person because of what you have ingested.
You are impaired.
Right.
And remember, you can be impaired. We're not just talking about alcohol.
Right.
You can be impaired from prescription medication. This is medication that you legitimately have every right to have. It's been prescribed by your doctor. But if it impairs or affects your ability to drive, if you are under the influence of that prescription medication, you can receive a DUI. Right. You can also, I know that there are a lot of people and a lot of young people who part of marijuana. You have to understand that if you are under the influence of marijuana and driving, it could result in you receiving a DUI.
Now, I will tell you, there's some old people who take marijuana and drive, okay? So, and it's legal. Now, see, here we fight with this thing of, just like alcohol is legal, marijuana over 18 is legal. So it's a matter of quantity and trying to make a decision to drive after you may have been under the influence of something.
Yes, the best thing is to just avoid it. Smoke your weed at home and don't go driving.
Or at the park and get a ride.
Sure.
But that's not going to happen, Carm. I think, that's like no sex and we won't have any.
That's not true, because there are ways that you can avoid it. You could, like you said, you could smoke at the park and walk home. You don't have to drive. So I'm encouraging use Lyft and use Uber. Don't take the risk of getting a DUI because the consequences are too great.
Yeah. And look, the real line is this. This is what I'm trying to say. How do you know you're under the influence of anything? How do you know? And that's the problem. Yeah. See, because
you're not usually necessarily the best judge of that.
And if you are, then obviously you'll never be caught. If you are the best judge of that. But you don't know, because all substances have a metabolism that goes on. So when they enter your body, they don't necessarily affect you right away. They have to go through the lungs, the blood, you see, in order to get into the system. And then as time moves on, whatever you have ingested will then move further into your system. If you continue to ingest, then more and more will be in your system at a later time. And so that's why when it comes to drinks, there's a general rule that every drink is probably a 0.02. So if you go out and you have 5 quick drinks, you're probably going to rise up to somewhere like an 06, 07, 08 almost, you see, pretty quickly. Now, you can rest for a minute, because the only thing that keeps alcohol out of your system is time. Alcohol metabolizes usually at a rate of 0.02 per hour. So that's how it will enter your system. and it also exits at a rate of 0.18 per hour. And most toxicologists would testify to that. So the only way to reduce the influence of alcohol would be time. If you waited 2-3 hours, then you've now dropped that BAC 0.04 to 0.06. So that's the science of a DUI and why it's dangerous if you don't know your limit, if you don't know how it affects you. So I think there's one more thing about DUIs that I wanted to talk about, but I think we covered it there. Now, there is another thing that I want to get to, and that's we talked last time, Carm, about the enhancements. Okay.
Proposition 81.
Yes, which changes Penal Code Section 1385. That's what I wanted to talk about. So I'm going to include DUIs in this because a lot of people believe that this statute says if you are charged with any enhancement of your sentence, then a judge must dismiss it, or following certain criteria that Carm had outlined before in the law, can dismiss it. They have at least the discretion to do so. And discretion, of course, means that a judge takes in certain factors in order to decide how to make a decision about whether enhancement stays or doesn't. And Carm laid out before that, if there's some aspect of the crime and the enhancements that involve danger to the public, that a court does not have to dismiss that enhancement. Now, a lot of people were getting confused because they were saying, well, what enhancements can be dismissed? And so there's been a big discussion regarding and an argument in courts over whether DUI enhancements, such as driving too fast, such as having a prior DUI, such as having a refusal or high BAC. Those are all things that we can call enhancements to a DUI. However, what the court has laid out and what law is that a prior conviction for DUI would not be an enhancement.
Even though it technically enhances or increases
your sentence.
The sentence.
Exactly. Now, we're going to juxtapose that to a strike offense on a person because we know it technically enhances the sentence, but it's very similar to having that prior DUI.
And just so we sometimes forget that not necessarily all of our viewers may know what a strike is. A strike is in California and many other states is a prior conviction that a person has, no matter how old, that can be used to increase the punishment on any new felony that they are facing.
And what kind of prior conviction should it be?
Well, there is an entire list of the prior convictions that are listed as either being serious or the ones that are listed as being violent.
Yes.
All strike priors are serious. Some strike priors are also serious and violent.
Right.
So we are talking about murder. We're talking about rape. We're talking about robbery,
kidnap.
We're talking about also burglary. Yes. A lot of people don't think about the fact that a burglary, which is not a robbery, a burglary is where you go into someone's home, no one is at home, usually.
Or home, yeah.
That turns it into a violent.
Into a violent, yes.
But no, a lot of people think a burglary, I just went into the home and I took some property. Nobody was there. I didn't harm anybody.
Right.
How can that be a strike? Because the law has classified that crime as a strike.
Right.
And it can be used against you in California, no matter how old it is. So it could have been 10 years ago. It could have been 15 years ago. It could have been 5 years ago.
Right.
And the district attorney has discretion to decide whether or not to file it. If they do, it can increase your punishment by doubling it if you have one strike prior. Actually, let me rephrase that.
Thank you. I was going to, yeah.
If the current offense is a strike prior and you have more than one, or if the current offense is a strike, I misspoke. If the current offense is a strike and you have 2 strike prior convictions in your past, no matter how old they are, if they are used against you, you could be sentenced to 25 years to life for each new felony, we have to remind people of that, of each new felony. So if you're charged with 4 new felonies, 4 residential burglaries, and you have, 2 robberies from 10 years ago, you could be looking at a total on that one new case of 100 years
Now,
to life.
and she's right. And the reason is because you can stack those because they're 4 different events. If you get 4 charges from one event, one crime, then that wouldn't be true. You can get to 25. They can give you 25, 25, but they got to stay it. So you only are served one 25 sentence. Now, I think though, how does it work when the present offense is not a strike?
So
Right.
when the present offense is not a strike crime, no matter how many strike priors you have, it can only be used to double the punishment. Now that still can run into some very substantial high numbers.
Because the triad, if a triad ends at 4 and you double, that's 8.
You're already at 8.
Now, that's not the only thing, Carm. One more thing about having a strike filed is you got to go to prison.
That is true.
Yeah.
If they're not just having it filed, but if they
Proven,
filed it
yeah.
and they've decided that they are going to proceed with using it against you, it means that you are not eligible for probation, and whatever sentence you receive will be doubled, and it will be an actual prison sentence, and not in county jail prison, but in real, actual, I like to call it big boy prison.
Or big girl prison.
That too.
They go too. So now we've got a strike prior. And in DUIs, if you have a prior DUI within 10 years of your present one, that will be used to up your sentence on the present one.
Enhance the sentence such that I would refer to it as an enhancement. And we have referred to them as enhancements for many, many years.
That's right.
But now a distinction is being made.
That's right. Because, and here's where it lies. So if I had 2 DUIs and I pick up a third, well, it's going to enhance it. If I had 1, it's going to enhance it. Now, but the way the SB 81 works when it comes to strike priors or a DUI prior is that it doesn't enhance it. It modifies the sentence that you can get. Okay? Now, there's a fine line because people can argue all day, well, it really enhances, but there is a difference.
I find it to be a play on words, lawman.
How you mean, Carm?
What I mean by that is this: it is a way to exclude it from this new law, which actually is more about looking at the individual person and things to do that are rehabilitative rather than just punishment, years.
So I'm going to give you a scenario, a hypo. I have a prior DUI that's 5 years old. Now, they can use it in order to get me in the new DUI I just picked up. So I picked up a new DUI tomorrow, and I have a DUI that's 5 years old, Carm. So are you saying that if you call it an enhancement, there's a reason why you should not use that 5-year prior against me?
Well, let me say this. I think that the DUI can be distinguished because even though the DUI is considered, there is not a set number in the penal code that you will get for having a DUI, a prior DUI, whereas there is a set number that we know that the triad will be doubled if you have a strike prior. So I think you can distinguish between the DUI and the strike prior, such that the strike prior, in my mind, should qualify as an enhancement.
Well, but wouldn't it be the other way around, that the DUI prior should not qualify as an enhancement because there's no penalty associated with it?
No, that's what I'm saying. I'm saying the DUI doesn't qualify.
Oh,
that
okay.
would be my argument. The DUI doesn't qualify as an enhancement, but a strike prior should, because we know what the strike prior does. If it's a case, it doubles the time.
Right.
And if you have 2 and the new one is also a strike, it puts you in a 25 to life state prison position.
Right.
So explain to me how that's not an enhancement when for years, how have we talked about them as strike priors that enhance the sentence?
Right. But I think we use enhance as it's defined in Webster's dictionary as more than what you can normally get. Now I will argue that the reason why it is not an enhancement is because it is not different behavior that is filed at the same time. For example, in both of the other cases, they're prior convictions that have nothing to do with the present offense, versus in a DUI, if I was speeding during the DUI, that's an enhancement. If I refused to test, it was during the current offense. If my BAC is high, it was during the current offense.
Oh, have they determined that those enhancements don't count as
No,
enhancements?
those are enhancements.
Okay.
That's why I'm saying that the argument is that because a prior DUI did not occur on the day I got my present DUI, just like a strike prior didn't occur on the day I got my present strike offense or new felony, that's why that's not an enhancement. But it is an enhancement if I use a gun in my present felony. It is an enhancement if I have a gang allegation in the present felony. If I have what used to be the 1 year prior, the 3 year prior, if the enhancement comes because of the present offense, behavior in the present offense. Like, for example, there are enhancements for how much money you may steal and how it may rise. So $50,000, maybe a 3 year enhancement, $100,000 a 5 year.
So are you falling for the language that because it's not related to the actual current conduct,
Yes,
that it's not an enhancement?
exactly.
Do you agree with that assessment?
I think I do.
I do not.
Well, I mean, this is why we have a forum, in order to disagree. But here's but you understand my logic. My logic is because what I call the enhancement enhances the present crime because of behavior done on that day. The others we're creating more of a sentence for you because of behavior done on a prior occasion. And that is the big difference, and why you should be able to strike the enhancements in the current cases and not the prior convictions that cause more time to be given. And that is a huge battle. Just to bring it all back around again, that's going to be a battle in the courts now as to what is an enhancement and what's not an enhancement. So people who believe that just because that I'm charged with a current felony that is not a strike, but yet you use a strike prior, it is not called an enhancement. Just like if I'm charged with a current DUI and I use my DUI of 5 years ago, that is not an enhancement. But me driving too fast, me driving with a high BAC.
Why is it not an enhancement?
It is not an enhancement because it didn't occur at the time the present offense occurred.
Oh, that's right. The play on words is that it is an alternative sentence structure.
That's right.
Except that it's an alternative sentence structure that is used to do what? Enhance your client's sentence.
To increase, not enhance. To increase.
Which enhances it.
Yeah, but see, that's what I'm saying.
A play on
You're
words.
going to go back to Webster's dictionary and say, well, enhance means to increase. But I'm saying the difference is, when does it occur? If it occurred in the past, then it's not an enhancement. If it occurred during the present offense, then it's an enhancement. I'm just saying what the courts and case law, as lawman, should follow that's what it's saying, and that's what's going to happen. But people got to know, look, the point is you got to know the distinction. Okay.
And so basically what we're saying is that if you're someone who has a strike prior and you're like, oh, Prop 81 has passed, my strike prior is going to be stricken as a result of Prop 81. What lawman is telling you is that the courts are saying, no. We are not counting strike priors as enhancements. So They are not part of what we will be considering. Now, the only reason that I say that doesn't quite makes sense is there is a section of Proposition 81 that talks about if the enhancement is 5 years or more old, that's one thing the court can consider. Well, something that happened at the time of the crime is not going to be 5 years or more old. So what were they talking about there? What were the legislators talking about? They were talking about prior convictions that are used to enhance.
But if at 5 years, I could use a DUI prior 1 year, 2 years, 3 years. I can use a strike prior 1 year, 2 years, 3 years. So maybe if they were talking about the priors, it had to be a prior over 5 years old.
No. Tell me what current, if that does not include strike priors, what current enhancement is going to be more than 5 years old? It's not. It can't be. It's part of the current crime. So there's no way for it to be 5 years or more old. So what were they talking about when they said you can consider if the enhancement is more than 5 years old? That would have had to have been strike priors.
Well,
there's nothing else. There's nothing that happens.
What? Well, what?
You tell me what happens at the time of the crime.
Here's what
that
I'm
can
saying.
Be 5 years old. Nothing.
All right, here's what I'm saying. I'm saying I may say that the legislature, if I may, that the legislature put that in there, and I don't think that anybody with criminal law understanding probably advised them that if they're going to say that
a lot of the legislatures are attorneys, so
the whole ledge council are attorneys who are supposed to review all this stuff, but they don't practice criminal law on a day-to-day basis.
So you're saying they don't know what they do in law, man?
Sometimes they don't when they create laws in subject areas that they don't practice in. See, that's my only point.
That they are not familiar with.
There you go. So if in fact they put that in there, I don't think they meant enhancements. You see what I'm saying? They might have meant some other behavior or something, but not enhancements. And even if they did,
I'm gonna read it to you.
You don't have to read it. You don't have to read it.
I want to read it to the people.
Have to read it. I read it to the people. Let's see if I can pick it apart.
I'm gonna let you do that.
All right, here we go.
Now I have to find that section.
It doesn't exist. Oh my goodness.
It does exist.
I don't. I think what they were talking about was if the present offense is 5 years old.
No, because the present offense would never
Find
be
the
5
thing,
years
Carm.
old. How would the present offense be 5 years old?
Because they don't
were
prosecute
sitting
it for
around
5
5
years.
years.
That's right.
They wouldn't
Statute
be able
of
to prosecute
limitations
it
not
then
over.
because the statute of limitations for most general
if I shoot a
felonies
gun,
is 3
though,
years.
if I shoot a gun, it could be 5. All right, let's see. Let's see.
So
and while she's here we go.
Multiple enhancements alleged in a single case. Anything beyond one would be dismissed. The current offense, not a felony. The enhancement is based on a prior conviction that is over 5 years old. The enhancement is based on a prior conviction that is over 5 years old. That is language directly from the statute. That's not Carmen B making it up. Do I need to let you see that, lawman?
No, I can see it from here.
I'm going to stretch it.
It's the H section. The enhancement is based on a prior conviction that is 5 years old.
So that's prior conviction. That's not talking about a current enhancement that's alleged in your conduct. Prior conviction. That is strike prior. That is strike prior all day long.
Well, it could be. But what I'm saying is I bet you we're going to see how the courts solve this problem. This is beyond Carmen B and lawman at this point. And we're going to see how they solve that problem. But I'm going to say that the intent of the legislature is not to use the strike prior, the DUI prior, as an enhancement that can be stricken under SB 81. But here's a good thing about litigation.
That it is.
Because guess what? This is an essence of litigation. What we're talking about here
is debate. Discussion.
Someone says something means something. Someone says something means something else.
That is correct.
And that's what we do in our daily lives. So what we don't do is we don't get to decide what that statute means, except when we make our arguments in court. It's going to be an appellate court that's going to make decisions eventually and who are going to decide what that particular section truly means in SB 81.
And that is usually what happens with any new law, is that the law has to be tested.
Yes.
And so I'm going to test it. And I know that lawman is in saying that is exactly, strike priors are exactly what that section is referring to, because it specifically uses the word prior conviction.
All right. We've come to the end of our class today on prior convictions and new laws and things like that. We want to encourage you to come on out, watch this. If you're watching it in another time, catch us on Fridays at 6 p.m. Courtside with
Lawman
and Carmen B.
All right. We
So
thank you for spending your evening with us. We ask that you tell others about us. We know
yes,
that there are people who have burning questions about criminal law, and they may not know where to go to get those questions answered.
right.
That place is right here at Courtside with Lawman and Carmen B.
And please stay safe out there. Protect yourself, protect your family. It's going to be very important at this time to be diligent. So, with that said, we're going to bid you adieu.
Have a good evening.